Namaskar. Today we are going to have a conversation about obtaining approval of National Biodiversity Authority for intellectual property rights under the purview of the Biological Diversity Act. A patent applicant who has used biological resources like plants, animals, microorganisms, or wishes to do so should seek approval of National Biodiversity Authority for their IPR. However, there are a number of concerns and doubts amongst various stakeholders, research organizations, individuals, and private entities about the course of this approval process. To answer these concerns and doubts, we have with us today the Secretary of National Biodiversity Authority, Shri J.Justin Mohan, who will answer our doubts straight away. Namaskar, sir.
Namaskar.
To begin with, what is intellectual property right and why does a patent applicant require to obtain prior approval from NBA for their IPR?
Thank you, Nirupa, for this interview, and thank you to all the viewers who are seeing this interview. IPR, or intellectual property right, is a right granted by the government to a person or an entity, which may be a company or an organization, for their invention. So this is a monopoly right which is granted to the IPR holder, with which he can enjoy possession of the creation for 20 years from the date of filing for that IPR. So in India, the IPR is actually granted by the Controller General of Patents, Trademarks and Designs. There are different types of IPRs: patents, trademarks, industrial designs, copyrights are the prominent IPRs in our country. In foreign countries, even trade secrets also they are giving IPR. So the IPR is governed broadly under the Indian Patents Act 1970. But when an applicant wants to take an IPR on a biological resource, like a plant, animal, or a microorganism, then he also has to take the approval of the National Biodiversity Authority under the provisions of the Biological Diversity Act 2002. Since India is a party to the United Nations Convention on Biological Diversity, the Biological Diversity Act 2002 has provisions to safeguard our biological resources and our traditional knowledge associated with such biological resources. In fact, this is the only law in our country which safeguards our traditional knowledge associated with our biological resources. So the spirit or objective of the Act is that our biological resources or associated traditional knowledge should not be prone to biopiracy. Someone in India should not take a biological resource from our country or a traditional knowledge and then get a patent outside India and start commercializing it without suitably compensating the people who have conserved these resources. So that is why this Biological Diversity Act was enacted by the government in 2002. And today, applicants come to National Biodiversity Authority, take the required approvals, and then with the approval, they go to the patent office for taking the intellectual property right.
Thank you for setting the context, sir. What are the legal provisions of the Biological Diversity Act which regulate IPR?
Under the Biological Diversity Act, there are two specific sections that govern IPR. One is Section 6, which states that any person or any entity has to take the prior approval of the National Biodiversity Authority when he wants to take an IPR on any biological resource or associated traditional knowledge from India. So an applicant can file his application for an IPR, and simultaneously he can also apply to National Biodiversity Authority. So within a month we will be giving the approval. So with that approval he can actually pursue his matter with the patent office to get his IPR issue. Under 18(4), that section specifies that National Biodiversity Authority can oppose any grant of patent issued by any other country on any biological resource obtained from India. So if a person or an entity has taken a patent on any biological resource or associated traditional knowledge from some other country, then National Biodiversity Authority will take necessary steps to revoke that patent and take suitable legal action against the applicant. So these are the broad provisions so far as the Biological Diversity Act 2002 is concerned. We have also notified the access and benefit sharing regulations in 2014, under which under regulation 9, every applicant who wants to take the approval from the National Biodiversity Authority has to commit himself by signing an agreement that he will share a small portion of his benefit in case he commercializes his patent or he is selling or assigning or licensing his invention to a third party. So he will have to give a commitment in the form of an agreement. So that is governed under the access and benefit sharing regulations that was notified in 2014. So these two legal instruments actually govern the grant of patent on any biological resource from the National Biodiversity Authority.
Sir, can you please brief us on how a patent applicant can obtain their prior approval from NBA for their IPR?
Any person who is desiring to take a patent or any type of IPR that is related to any biological resource or associated traditional knowledge, he has to register himself in an online portal which is available in our official website www.nbiindia.org. On the right hand side of the website we have an ABS portal. There is also a video demonstrating how an applicant has to fill in the details and apply to the National Biodiversity Authority. Now once the registration process is completed, he can just pick form 3 which is pertaining to IPR and then provide the required details. The details would include the name of the applicant. If there are more than one applicant, you have to declare that these are the joint patent applicants. You also provide the address along with the ID proof issued by any government authority. It can be an Aadhaar card or a passport. Some government issued ID proof also has to be enclosed. You also have to provide the details of the invention and the type of resource, biological resource which you are going to use in the invention, and from where you have accessed, the geolocation from where you have actually procured or accessed those biological resources, because the benefit sharing which you are going to pay in case you are commercializing will be going to those areas or to those communities from where you are accessing these resources. Once you input all the details in the online portal, you also have to pay a fees of ₹500 online, and then once everything is done, you have to submit it, and then automatically the system will provide you an acknowledgement. That acknowledgement will give you an application number, and with that application number you can follow up with the National Biodiversity Authority. In normal course, if all the details are provided, we grant the approval within a month. So you have to provide all the required details, and then you can expect a draft agreement from the National Biodiversity Authority providing all the required information, and then you have to sign the agreement once you receive the draft agreement, and then that constitutes the approval. So you can take the signed agreement, that is signed by both the parties. From the National Biodiversity Authority, the Secretary NBA will sign, and from the applicant side, the applicant or the joint applicants who are going to apply for the patent, they will sign, and then the agreement can be produced before the patent office for following up to get the patent issued.
Sir, since NBA signs an agreement with the applicant, what are the provisions of this agreement and how is access and benefit sharing incorporated in this approval?
Okay, this agreement is just like any other agreement. It has to be signed on a non-judicial stamp paper worth 20 rupees. And we will be giving the draft agreement to the applicant, so there is no problem for the applicant to create an agreement. So that is a standard agreement we have for all the IPR related applications. So he has to fill in only those areas where which are specific to him, like the name of the applicant or his address or the type of resource he is using or from where he is collecting. All those details which are specific to the applicant only has to be provided. So we have also designed a guideline for the applicant to fill those details. So that will also be provided along with the draft agreement. The agreement per se will have all the provisions like the name of the applicant, address, where the biological resource has been procured, what is the time frame for this agreement, the tenure of this agreement, and where what are the type of resources he has used, what is the quantity of resource he has used for his invention. All those details will be provided, and there are different schedules broadly there are two schedules. Schedule 1 pertains to the benefit sharing which he commits himself in case he is actually commercializing the product or he is going to sell the product. And also there is Schedule 2 or Schedule B, where there are 4 annexes where he has to provide the details of location from where he has procured, the nature of the biological resources, quantity, and also a brief about his invention. So once he receives the draft agreement from the National Biodiversity Authority within a month, and he has to execute it on a non-judicial stamp paper worth 20 rupees, and then after signing the agreement he has to send it to NBA. We will cross-check it, and then from NBA the secretary will sign, and then that constitutes the approval. So if there is any doubt which the applicant has, he can always come back to us. There is no need for the applicant to come to NBA physically. He can just communicate to us on email, and we will be giving the required information to them.
Sir, if an applicant falls under Section 3(2) of the Biological Diversity Act, what are the norms and regulations for such an applicant?
Okay, so broadly there are 3 categories of applicants who apply for IPR. One category are Indian citizens or Indian companies. So for them they have to just pay 500 rupees and pick Form 3 and then provide all the details in the online portal, and then they get the draft agreement, then they execute the agreement on stamp paper. Then there is another category of IPR applicants, that is companies who are Section 7. Section 7 companies also have to just fill the application just like individuals, and then they get the draft agreement, and then they fill the agreement and then sign it, and then that constitutes the approval. The third category is the Section 3(2) entities, which are who are non-Indians, non-resident Indians. Non-Indians means foreigners also, overseas citizens of India, and also companies who are covered under Section 3(2) of the Act. So for them, apart from Form 3, they also have to apply in Form 1, because the Biological Diversity Act broadly governs 3 types of activities. One is commercial utilization. So if someone is using biological resource with a commercial motive, he has to share a portion of the benefits to the communities who are conserving them. Then the research. So if there is a 3(2) entity, 3(2) person, Section 3(2) person, research is regulated under the Biological Diversity Act. Then the IPR. So since research is regulated under the Biological Diversity Act, if the person is a Section 32 person having a non-Indian identity, or he is covered under Section 32, then he also has to file Form 1, which is pertaining to research. So he has to file two applications, one in Form 1 and one in Form 3. And once both the applications are filled, and then you get the draft agreement and you sign it. And from MBA side, after checking legal scrutiny and scientific scrutiny, we also check it and we sign the agreement that constitutes the approval.
Sir, if traditional knowledge has been used in the invention, how is access and benefit sharing incorporated in the approval process?
Okay. So far as the benefit sharing is concerned, it is governed under the access and benefit sharing mechanism, which is prevalent in India. And this is governed under the Access and Benefit Sharing Regulations 2014. Section 9 broadly defines how this access and benefit sharing will be regulated so far as intellectual property rights are concerned. So there are three scenarios. If the IPR patent applicant himself wants to commercialize his invention, either the process or product, then he will have to commit himself that he will pay between 0.2 to 1%. Generally, if the applicant comes and takes the prior approval, we fix 0.2 as the benefit sharing obligation. So we fix the lowest slab. So he will commit that he will pay 0.2% of the benefits which he is going to get after every financial year as part of his benefit sharing obligations to the communities. The scenario number 2 is when applicant actually wants to sell the patent or IPR to a third party. He does not want to commercialize himself. He wants to sell it or assign it or license it to a third party. Then he has to pay between 3 to 5% of the monetary consideration which he is going to get during the time of selling the patent. Then there is also a third scenario where the applicant not only wants to sell the patent but also he wants to get a royalty on it. So in that case, apart from paying between 3 to 5% on the monetary consideration at the time of sale, he will also have to pay between 2 to 5% on the royalty which he is entitled to get at the end of every financial year from the buyer of the patent. So these are the three scenarios in which he has to commit himself under the benefit sharing process.
Sir, what would be your advice for patent applicants who wish to obtain their IPR or the NBA approval without delay?
So, if you see, if all the required inputs, applicant inputs all the required details that is sought by the National Biodiversity Authority in the online portal, like the name of the applicant, address proof, ID proof, then the details of biological resources, the authorization letter from the head of the organization, and the geolocation details, all those details, if they are actually incorporating in the online portal, you will get the approval from the National Biodiversity Authority within a month. Now what happens is many a times the applicants do not provide the details, or there would be a mismatch between the details that they are providing to the National Biodiversity Authority and to the patent office. So whenever we get an application, we also cross-check the details which the applicant has provided to the patent office. So if there is a mismatch with respect to the name of the patent, say patent applicant provides only one name here in the National Biodiversity Authority and he is providing more than one name to the patent office, there is a mismatch. Or if there is a mismatch in the quantity of biological resources or in the type of biological resource, species of resource which they have accessed. So if there is a mismatch between the details provided to the National Biodiversity Authority and to the patent office, then we ask for clarification. That delays the process of granting the approval. So In sometimes what happens is applicants take the help of patent agents or attorneys. So in that case, we normally correspond with the patent attorneys or the lawyers. So in that case, the applicants will have to constantly monitor with the patent attorneys or the law firms and find out if NBA wants further details on their application. That would actually help them to reduce the delay. And once all the details are provided from NBA, we have already given strict instructions to our officials that every patent applicant is an intellectual asset for our country. So from our side, we generally do not delay granting of approvals unless the patent applicant is reluctant to provide the details required by the National Biodiversity Authority. So whenever some additional inputs are requested from our office, the patent applicant should provide it, and then still if there is any problem or difficulty which he is facing, he can directly communicate to the section head of the IPR section in the National Biodiversity Authority. And still if the problem is not resolved, he can always communicate to the Secretary National Biodiversity Authority. We are there to take care of the difficulties faced by the patent applicant. Many a times what happened, there may be genuine problems, like for example, say a scientist. Many a times what happens is many of the applicants are from the scientific background. They come from universities, scientific institutions like the CSIR, ICR, ICFRE, state government universities, colleges. So for them, getting a patent is some sort of a professional accomplishment which helps them in their career. So whenever they are filing the application online, actually what happens, many a times they may be facing difficulties. Say for example, they have procured a particular resource from a trader some 5 or 10 years back, but they may not be having the invoice of purchase. So in such cases, as per existing rules, we normally ask the source from where they have procured. If they are not having the invoice from where they have purchased, then they can always give a declaration. So we will actually help them by avoiding further queries on that. So a self-declaration will suffice. Similarly, if there is any difficulties in getting an authorization, see normally what happens is the officer who is actually filing the applicant should be authorized by the head of the institution. Say in the case of university, the head of the university is the vice chancellor, whereas the applicant may be another person. He may not be the vice chancellor. So the vice chancellor should actually designate a person in the university who is authorized to file the application before the National Biodiversity Authority. This also holds good for the companies. Many a times what happens is persons without any authorization from the company CEO, they will also apply. So we will ask them to produce the authorization. So the CEO will have to designate a person who will actually take care of the IPR related activities of the company. So a proper authorization letter should also be enclosed by the applicant. That will also reduce the delay. So if the applicant produces all the required documents, that is, it's a self-explanatory portal. So whatever details are required in the portal, if you can provide, and also if there is any additional information which NBA is asking, that also if you can provide directly, you are rest assured that within a month you are going to get the patent. And for Section 32 entities, you will have to declare that you are a Section 32 entity, and in such case you will also have to file Form 1 along with Form 3. So together we will grant the approval within a month. So since this is only a research application, so Form 1 and Form 3, we will together, you will have to sign 2 agreements, and then together we can grant the approval within a month. So if there is any difficulty which you are facing, you can always directly correspond with the Secretary of the National Biodiversity Authority.
Sir, I am sure today's interaction will be an eye-opener for all stakeholders to understand the process of obtaining approval from National Biodiversity Authority. I take this opportunity to thank you for taking time for this interaction amidst your busy schedule. Namaskar.
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 Thank you.